Welcome back to the Dummy Kruger channel, everyone. Today, I'm excited to bring you an updated version of a video I released back in April of this year. The third and final part of one of the most absurd court cases I've ever come across. The original video was taken down under the quote bullying and harassment policy, as I apparently didn't redact enough personal information from 25-year-old court documents at the time. In this updated version, I've significantly redacted that information. While it may not be as transparent as before, it's the only way I could get it back up. Throughout the video, I'll also jump in to share updates on what's happened since the original upload. Let's get to it. Welcome to the Dummy Kruger channel, everyone. Before we get to the main topic of today, I wanted to briefly touch on a development that has taken place since I released my previous video last Friday. Shortly after I premiered the video, For Public Safety went live on his channel to announce he was submitting a bar complaint against attorney Larry Foreman, also known as the DUI guy on YouTube, for allegedly disseminating Chris's private information that included his date of birth and address. Chris is alleging this took place during an interview that happened last month between the two of them. He did this in retaliation because Larry assisted me in obtaining records to produce that video, as well as this one. However, as you will soon see, that's not what happened at all. Let's tackle the birth date first.
Your guess is as good as mine on this whole case, because it never happened. What they were alleging never happened. There was no case in 1999 involving me in Hardin County, Kentucky for drugs. So I was shocked. I didn't know.
Wait.
At the same.
There was no marijuana case at all?
That never happened in my life. So I was baffled. I just thought, okay, I know what you're doing.
Hold on a second. Hold on. Never in your life have you been charged with marijuana in 1998, 1999?
Never in my life, period. I've never been charged with any kind of drugs, never any alcohol-related charges.
What's
never
your date
in my
of
life.
birth? Okay, I'm about to share something on screen. Please follow along with me, okay? Because I'm very, very confused right now.
Larry asked for his date of birth, which you can see Chris give voluntarily because he wanted to verify that he had the correct person, which he did. Next up, while they were discussing the case, Chris's address was shown while looking at his records. Some in the chat inquired with Larry while this was going on if this would be considered doxing, and then this is what happened.
There's no doxing. I'm not doxing anybody, I promise.
Right, and I'm approving all of this anyway. There's nothing.
Yeah, so let's get back. I'm appeasing chat because chat is getting a little feisty.
Chris said, and I quote, "I'm approving all of this anyway." Chris, you don't get to take that back now that you're angry with Larry. It doesn't work that way. There's also one tiny little issue that Chris should have been aware of before going on multiple live streams reading off this bar complaint. When filling out a bar complaint, there are rules one needs to follow while doing so. In Chris's defense, there are 10 in total, so maybe he just missed it. Oh, wait. It's rule number 1. He probably should have caught that one. It reads, Supreme Court Rule 3.150 provides this matter is confidential until the Inquiry Commission or its chair has acted. Given Chris is an investigative journalist, I'm sure he took the time to investigate what this Supreme Court rule says. Would you look at that? Number 1 again. What are the odds? It reads, confidentiality. In a discipline matter, the proceeding is confidential prior to the filing of a verified answer to a charge. And finally, this next one is definitely not Chris's fault because he would have had to scroll all the way down to number 3, duty of participants. All participants in a proceeding under these rules shall conduct themselves so as to maintain the confidentiality requirement of this rule. Chris, rule number 1 says you have to keep this confidential upon filing, which means you kind of already blew it when you went live streaming for hours about this bar complaint. Oh well, strikes and gutters, ups and downs. Let's get to the story. Really quickly before we get started, the bar complaint that was submitted last spring was officially tossed out almost immediately without even a hearing. Back to the video. Today's video takes us to Hardin County, Kentucky for yet another follow-up to the mysterious case where someone pretending to be Christopher Ryder is issued a citation for possession and drug paraphernalia, goes to court weeks later to plead guilty on his behalf, hires a private attorney to represent Chris, even though it's not Chris, pays court costs, and even appears for drug screenings weeks later. That's right, everyone. It's time to once again attempt to find this imposter. But this go around, I have even more ammunition thanks to attorney Larry Foreman, aka the DUI guy. Here's Chris talking to Larry through a live stream of his about the case.
I can't read that. It just keeps moving. You don't want to get me convicted on your channel. You dig? Yes. No, I appreciate that. But what you were doing there was more of the same argument that the state's been bringing. You read out the argument the state's been bringing, and then using Dummy Kruger's video, which he did not do a records request, by the way.
In fairness to Chris, I did use a lot of the state's argument because it was the only argument that made any sense. And now that I have the entire record, it's even worse.
Nobody requested the records. I wouldn't care if they did. And you're more than welcome to if you want to do that on your own.
Now, of course, Larry didn't need permission to request all of the records, but it was nice of Chris to let him know he was welcome to. So, Larry did request the records from multiple counties concerning this case, all except for the actual hearing that took place in November of 2023, because that record was sealed in February of 2024. However, I already had a copy of it, and it can be found on multiple YouTube channels, including for public safeties. For a quick refresher, this is what we will be tackling today with the help of the entire case file.
So this whole entire case from 1998, not 99 like John Goldsboro, the arresting officer, said, was concocted out of thin blue air.
It never happened. Like what they were alleging never happened. There was no case in 1999 involving me in Hardin County, Kentucky for drugs, you know.
And these are the charges. Absurd possession of marijuana, it's just weed, man. It's 1998. Is this not you?
No, I that's what the whole case is about. So I had to go to court because I had no idea what this case was. It never happened to the real life me. I don't know what else.
So hold on. So you're saying, because I'm very confused. This was part of your file, right? This is part of your file. So you're saying this is what? This is fabricated? This is clearly you're saying it's not you. I got that much. Yeah. But who would fabricate your name and date of birth? And I'm just curious, like, do you know anybody who might impersonate you like this? This seems just really odd.
Well,
I mean, as an attorney,
yeah.
I've never seen anything like this before.
I'm going to first tackle some lingering questions I still get from some of Chris's followers, one of those being why there was no mugshot or fingerprints. There was no mugshot or fingerprints because in 1998, Chris received a citation only to be summoned to court on a later date. There was no arrest. Saying that, I actually understand why a lot of them are still confused about that because Chris has been deceiving them about this for an entire year. Chris's response to my first video where I showed all of this was to claim I took his videos and manipulated the dates to make him look bad, with him also saying I presented things as fact while he claims they were his opinion. Neither are true. What I'm going to do next is kill two birds with one stone. I'm going to show you clips from my original video that discusses his mugshot and fingerprints, but I've added the dates to the clips. And then I'm going to show you a clip of when he actually learned there was no arrest, thus no fingerprints or mugshot, because it will prove without a shadow of a doubt who is being deceitful. I guess that's three birds with one stone.
Booking photos, well, then again, yes, there was, but they don't have them anymore. And that's part of what puts them in a better position to use a case from 1998, right? So, and I think that they have the burden of proof, right? They have the burden of proof because they're not going to show the fingerprint. They're not going to show the mugshot in that courtroom. So if you guys won't do that, then why shouldn't I be released? Obviously, there's a reason you're not going to show that to the judge. Why would it be? There's only one answer I can think of. If you have it and you won't show it to them, the only thing that means to me is there's a reason you won't show it. What is that reason? Guys, put in chat what that reason is. I'm not even going to say it. I'm going to let you say it. Here's the reality of a case like this. If a person really had committed some type of crime back in 1998 and then managed to avoid law enforcement for 25 years and then was caught, right? If that really truly would happen, it'd be real easy on their part. If someone came into court and said, wasn't me, it'd be real easy. What they would do is they would say, here's the fingerprints, here's the mugshot, here's the video of that person in court, which all existed back then, all of it, and it's supposed to be on this record, but they don't have it. Those are the things they're missing. Exactly those things are missing. The fingerprints, the mugshots, and the video from court. Missing. And not only that, but they are missing imperative portions of those records that they absolutely have to retain by law. If there's still an open case, they're not allowed to throw away anything out of that record. So here's what they've thrown away: fingerprints, mugshots, video of the courtroom, which was on VHS at the time. They throw it away. And they've admitted to throwing it away. They're saying we disposed of those particular portions of this record. That's not how it works, y'all. All of the rest of the file that would actually prove a person's guilt, like mugshots or the video of the court or any of the other documents in the entire record that would have been substantial enough to say this is the person they conveniently had destroyed on purpose.
On March 4th, he specifically said there were booking photos, but they are no longer available. On March 6th, he speculated that the county might be withholding the mugshot and fingerprints for reasons related to a possible imposter scenario. On September 5th, he says as fact that a mugshot and fingerprints existed for the case, but are now missing. On October 13th, he once again says they threw away the mugshot and fingerprints. And finally, on December 7th, 9 days after the hearing had concluded, he was still telling his audience that they destroyed the mugshot and fingerprints. Now, the video in question I was told personally wasn't available, so he was telling the truth about that. However, would anyone be surprised that Chris learned all the way back on January 9th, 2023 that no mugshot or fingerprints ever took place because there wasn't an arrest? Yet for almost an entire year afterwards, he was lying to his audience, making them believe they did exist, but were destroyed?
So what I'm telling you is I need the fingerprints where that person was booked in here, and I'll be done.
I don't
Game
know how
over.
to get it, to be honest with you.
Mugshot.
Well, I mean, that's what I'm saying. We can't find anything else.
But you
at
booked
all.
somebody.
As of right now, still, we don't have a.
That is the original. It's a copy of the original right there. It ain't in there. What's missing,
I know,
Josh?
but what I'm saying is that we don't have anything on our file where any arrest was made back in 1998.
Let me tell you what's missing. I'm hearing you. What's missing is fingerprint file and the mugshot.
Yep. But
Why
if
ain't there a booking photo?
But it's showing there's nobody that's ever booked in that time and that date, all that stuff. You know, when that.
What do you mean? You're saying this never happened?
Well, I'm saying back in 1998, there was an arrest ever made. I mean, the way it looked.
After a few more minutes of them going back and forth, the jailer finally asked Chris if he could look at his paperwork. That's when the jailer quickly realizes that no arrest ever took place.
I just don't.
He let the guy get away with having a different address than
That's
what
what
was
it
on the
is.
license.
That's what it is. Look here. So there wasn't actually an arrest made. That's a criminal summons. That was.
That's what I said.
That was sent to somebody's house as a criminal summons.
That's what I said.
So that's why there's nothing else in the system.
I'm seeing what
because
you're
it was
saying.
just a criminal summons.
I thought that at first. I thought that.
Booking photos. Well, then again, yes, there was.
So that's why there's nothing else in the system.
I'm seeing what
because
you're
it was
saying.
just a criminal summons.
Because they're not going to show the fingerprint. They're not going to show the mugshot in that courtroom. So if you guys won't do that, then why shouldn't I be released? Obviously, there's a reason you're not going to show that to the judge. Why would it be? There's only one answer I can think of. If you have it and you won't show it to them, the only thing that means to me is there's a reason you won't show it. What is that reason?
So that's why there's nothing else in the system.
I'm seeing what
because
you're
it was
saying.
just a criminal summons.
If someone came into court and said, wasn't me, it'd be real easy. What they would do, what they would do is they would say, here's the fingerprints, here's the mugshot, here's the video of that person in court, which all existed back then. All of it. And it's supposed to be on this record. But they don't have it. Those are the things they're missing. Exactly those things are missing. The fingerprints, the mugshots, and the video from court. Missing.
So that's why there's nothing else in the system.
I'm seeing what
because
you're
it was
saying.
just a criminal summons.
So here's what they've thrown away. Fingerprints, mugshots, video of the courtroom, which was on VHS at the time. They throw it away. And they've admitted to throwing it away. They're saying we disposed of those particular portions of this record. That's not how it works, y'all. All of the rest of the file that would actually prove a person's guilt, like mugshots or the video of the court or any of the other documents in the entire record that would have been substantial enough to say this is the person they conveniently had destroyed on purpose.
Look here. So there wasn't actually an arrest made. That's a criminal summons.
Speaking directly now to Chris and Tiffany's viewers, you've all been hoodwinked. I'm sorry. Let's now get into some of these newly obtained documents. One of the first things Larry and I learned is that Chris wasn't cited for just a joint, or a marijuana cigarette as he likes to call it. There was more to it.
And I know there's probably some pretty crappy attorneys out there, but what attorney would have their client plead guilty to one single marijuana cigarette? Because let's face it, we're talking about a case, an alleged case, involving one single joint.
So Chris was originally hit with 2 charges. The first one, possession of marijuana. Per the police report, the officer wrote, "Upon checking the welfare of a minor, when we were inside the residence and found a small baggie of marijuana, which was inside the kitchen cabinet, given to us by a resident." That's important because Chris went on and on and on about how they could legally check the kitchen cabinet. But it looks like Chris informed the officer that it was there. Number 2, possession of drug paraphernalia. Upon checking the welfare of a minor when inside the residence, I observed a scale and rolling papers on the kitchen table. Chris wasn't cited for one single marijuana cigarette like he's been claiming for the past year, because from the looks of it, he was possibly selling some ditchweed Kentucky dime bags. Another question that I often received was, who was this attorney that represented Chris, and why can't anyone seem to find them? Chris has said on multiple occasions that he thinks some of the records have been manipulated because he couldn't locate the attorney that he hired to represent him. But I did.
On September 23, 1998, the defendant appeared with a private attorney, B.J. Holycross.
And hey guys, if anyone in this whole world is watching this channel who knows who the hell the attorney B.J. Holycross is, let me know, because I'd like to meet him. I don't remember ever knowing any B.J. Holycross in my whole life. And I've been searching and I can't find a B.J. Holycross.
This is the only B.J. Holycross that I could locate who is an attorney who fits the profile. Reading her bio, she says she went to undergrad at Murray State, which is located in Kentucky. She then went on to get her law degree at SIU. Even though she's currently located in Virginia, she mentions that she's licensed in 3 states. Now, even though I could not locate a B.J. Holycross as a member of the Kentucky Bar, I figured I would at least attempt to contact her. Well over a month ago, I sent her an email explaining that I was seeking an attorney named B.J. Holycross who may have been practicing law in Kentucky in 1998. I explained to her I was reaching out to her and even linked my video for further clarification. Unfortunately, I never heard back from her, so I thought it was a dead end. That was until I thought about her first name being short for something. And that's when I confirmed it was indeed her, and she is still a member of the Kentucky Bar Association. Her full name is actually Billy Joel Pole Holycross, and the address that I redacted matches another address of hers in Virginia. Finally, towards the bottom of the page, it gives the date of admission, October 18, 1996, giving her ample time to represent the fake Christopher Ryder, and officially decimating yet another one of his conspiracies. BJ, shoot me an email sometime, I'd love to chat. Let's now move on to the one big gotcha that Chris thought proved it wasn't him, when it turns out to be just one big hoax. Let me explain. For the past year, Chris has claimed that DCS, the Department of Child Services, was with the officer at the location where Chris was cited in 1998 at 3:30 in the morning.
So, according to his report from 1998, he had gotten a call to assist the Department of Child Services to go to the address that you see on that court record. They said that they went to, so Evangelista said that he went to an address, okay, and that he was there for the welfare check of a child through Department of Child Services.
They were saying that they got a call for a child welfare incident involving the Department of Child Services, but that never happened either. Okay, so it's a person with a kid, right? Who got DCS called on them, and then the cops went in. This is according to the report, a 1988 report, but it supposedly happened in 1998. A cop was called to go with a DCS person into someone's house, but they're saying that a parent of a child, had DCS called on them, and then DCS went to that parent's house. You know, it's a lot. If you go, so this guy got arrested for a joint because we went to his house with DCS for his kid.
Did you say
and then
DCS was
and then you
involved?
find out the dude don't have a kid, then you know that's wrong, right? How do you not fix that? What?
Did you say DCS was involved?
Yeah, they had DCS go with the cop. That's what the record says if you read it. That DCS went in the house with the cop, and the cop went into the cabinet of the person who owned the house.
Okay.
Did you notice in that last clip where Tiffany tried to speak up but was quickly shut down? Tiffany at this point was more familiar with anyone with this case. She knew Chris wasn't being truthful here, but let it go. So Chris, in all of his wisdom, set out to prove it wasn't him by presenting 2 documents in court showing that he, his then girlfriend, or his girlfriend's child never had any DCS involvement. Thus, conspiracy.
When you found out that this run to this address, wherever it was based on a complaint involving a juvenile, did you take steps to find out if the cabinet had any records of a welfare check in your name?
Absolutely.
I want to show you these documents here, and I think the Commonwealth indicated they had no objection to them, Your Honor. So these are.
I'll point out that I don't believe you're certified, but that's fine, Judge. No objection.
So moved.
Okay. Just tell the court what you did and what response you received for the Cabinet for Health Services.
Well, I went to Kentucky's Department of Child Services and Family Services to see if there was any records that might indicate anything about this case. So I asked for all records that might have involved my name, my social security number, anything that there was about me, including the person that I dated from that long ago. And they responded with this. Well, they responded with that there were no records available because there were none.
There are 2 points that need to be made here. First, the officer testifies that he has no idea where the call came from. It could have been from a neighbor, it could have been from a family member, it could have even been from someone inside the home. What you won't hear, however, is that there was any DCS involvement whatsoever like Chris has claimed was in the police report.
Would the welfare check have involved, if you recall it, and believe me, I understand it's 25 years ago,
Sure.
would the run have involved juveniles, maybe children?
It would have been, because I noted on the citation that it was the welfare check of a minor, so that would have been likely what it was for.
So who would traditionally have been involved in notifying the Radcliffe Police Department about the need for this welfare check of a juvenile?
So that varies. I couldn't speculate on how who would call for that, but we would just take advice on our dispatch. Likely the call came in through our dispatcher. I don't have any knowledge on the source of the call.
Okay.
The prosecutor quickly jumps on this and asks what the relevance of these documents are because there's no mention of DCS anywhere.
Of course, I think most of this is already in the court file, but as to these cabinet letters, I guess my only objection would be relevance because there's not been any allegation or assertion that there was cabinet involvement that day. The officer testified they could have got a welfare check request from a variety of sources. He doesn't know. So
I'll note that for the record.
Yes, sir.
But remember, that's not what Chris has been telling his audience.
They just do not want to admit that it absolutely says in these documents that the call was initiated by the Department of Child Services of the state of Kentucky.
And that's another thing that I want to make more clear, because apparently, people are now being confused because apparently Dummy's video was not really pointing on important stuff. The joint that was found according to the police report, and I have to say according to the police report, because I wasn't on the police report, it says that the cop says I was joining Department of Child Services that got called for a child welfare call. And I came to this residence, and this is what the cop's saying. In the documentation, I can give it to anybody. I'll publish it on my channel.
You'll never believe this, but Chris never provided these documents like he said he was going to do, showing DCS was involved, and he never will, because it was a lie he was feeding his audience. Like the prosecutor said, there was never any allegation of DCS involvement in court whatsoever. Only on YouTube. Let's now move on very quickly to Chris's name being misspelled on some of these court documents, because it's actually quite hilarious after seeing exactly how it happened.
Horrible cop.
Yeah, he was like, so I misspelled his last name whenever I wrote it on citation. He's
No
like,
big deal.
that's what all the little marks there. I tried to
3
correct
letters
it.
out of a 6-letter
I
name
was like, really?
wrong. It's no big deal. That's no big deal, right? But it was 3 letters disorganized, which that doesn't make much sense. If you're a cop and you're saying, well, I had some scribbly writing, Why would you have 3 letters completely jumbled and wrong? That doesn't make sense. That's too much. So that should have been brought out in questioning anything about that case, in my opinion. That's right. They didn't even have my name. They had another name spelling, which was 3 out of 6 letters different than mine.
And this is what the officer said on the stand who wrote the ticket about the misspelling.
And I wanted to call your attention to the name there. There's some question about the spelling of that name, and what do you see there as far as what's on your citation?
Right, based on what I now know, of course, with the correct spelling of the name, there appears to be some misspelling on that last name. And there is, when I was writing it, I believe I may have not seen that extra E, so I think I tried to just add the E in there. So it's poor penmanship on my behalf, I would assume. So.
Let's take a look at the citation that led to this misspelling, shall we? So it's just like the officer said. He wrote out R-E-I-T-T-R, but he did try to fix his mistake by adding 2 lines to that second T. This is clerical stuff. This isn't conspiracy stuff, Chris. And what did you say just a couple of months ago about this misspelling?
That's right. They didn't even have my name. They had another name spelling, which was 3 out of 6 letters different than mine.
It's like he can't stop lying about even the smallest of things. And Chris, I have to ask, why didn't you tell your audience that this name misspelling eventually got fixed? In 1999, on an affidavit to revoke your probation, your name was spelled correctly. When a motion was submitted to revoke that probation, your name was spelled correctly. And when they officially revoked your probation, your name was spelled correctly. Okay, I want to now touch on what I think is the best evidence that the prosecutor used to prove it was Chris, the matching signatures from 5 separate occasions. First, here's what Chris says about the 2 signatures from his bond paperwork in 1999 that Larry and I covered extensively in my previous video.
The prosecutors have gotten so desperate in this case that I believe that they have even fabricated records in my real case documents from back in that time era just so that they could put a false signature, because that's all the prosecutor really had to use, was to suggest that they had matching signatures from the fake case that they're bringing to this court and in another case which actually existed, but the document in the other case that actually existed couldn't have existed. It was a bond form saying that I bonded out of a jail in 1999. But I did not bond out of the jail in 1999. I stayed in the jail until the final hearing, in which I saw the judge and then was released. So where did that record come from? I'm not real sure. Somebody probably slipped that in there. I still don't know.
And there are 2 signatures in that case.
So these are the 2 signatures that the prosecutor is referring to. If you haven't seen that video yet, take a look, because it was proven that he did bond out on April 5th, 1999. Thus, these signatures are real and they are Chris's.
There are 2 signatures in the 1998 traffic case.
In regards to the traffic case that he's referring to, we will be doing a deep dive later on in this video about it. But, as you can see here, one of the signatures comes from him agreeing to probation, and the other one comes from an insurance policy that he took out with his then girlfriend, Georgette. More on both of these signatures in a little bit.
And there are 2 signatures in the Hardin County 98 possession marijuana case.
The first signature in the 98 imposter/possession case came from him agreeing to the terms and conditions of his probation. The second signature that the prosecutor is referring to came from him agreeing to random drug testing through a company called CAPS.
Your Honor, you don't have to be a meteorologist to know it's raining outside. And you don't have to be a handwriting expert to know the same person signed every one of those.
The prosecutor is right. It's obvious that Chris signed all of these documents. Therefore, it's Chris, not an imposter, nor a manipulated record, who was cited and pleaded guilty to in 1998 for possession of marijuana. Now, who wants to see Chris explain to his audience why all of these signatures look like they came from the same person? Because, honestly, it's the funniest clip he's ever produced. Who's ready to laugh?
Took the liberty, this is a demonstrative exhibit from those various cases, Your Honor, if I may approach. 98N 51948, as well as the two Meade County cases, a side-by-side comparison made by copying the various signatures, Your Honor.
Did you catch that? He said, made by copying various signatures, Your Honor. Well, I would have to agree with that, because when we looked at the signatures that prosecutor turned into the judge that day, they all looked copied on top of each other to us in both the Meade County and the Hardin County file. Copied off of each other.
Yeah, you heard that right. The Comic Sans of the 1A community believes the prosecutor just admitted to committing forgery by copying these signatures seen here on top of one another. That's why they look so similar. It's not because Chris signed all of these documents. No, couldn't be. And the prosecutor couldn't have possibly meant photocopying all them on this one single page, because that would make too much sense. At this juncture, I'm not too sure if it's more hilarious or sad that people actually buy into this. I'm going to probably go with hilarious, because if his supporters don't realize they are being conned by now, I don't think they ever will. Okay, next up we're going to once again tackle my favorite part, the physical address that the citation was given. Bear with me, because this gets a little convoluted, but now I have 100% proof that not only did Georgette live at this address, but so did Chris.
The address that they said the incident occurred, the arrest, was never in existence in any time in history.
And also, I believe the original court file, what is the address you have listed on it?
The address that I had responded to was 137 Morgan Street, and it would have been lot 246.
Okay. Not 2461.
No.
Okay. Do you know where someone would have come up with that?
The address in the offender violator section looks like that may be a 1 at the end, but that likely could have just been some over-marking from another piece of paperwork I was filling out, perhaps.
Okay, take a look here. 137 Morgan Street, lot 246-1. Now, the officer is saying that this is an overmarking and it does not match any of the other ones on the paper, which is true. Because of this errant dash, some of the subsequent court documents listed lot 2461. However, it's very easily explainable.
But the exact location of the arrest and violation, as noted under the date and time section, does reflect lot 246.
And once again, this gets easily cleared up after hearing his testimony, plus seeing the actual document. This address does exist, but it does get a little bit more confusing, especially if you're listening to Chris. Watch these clips, then I'll be able to explain everything.
Now remember that address, 137 Morgan Street, because later the prosecutor is going to say that because he found some evidence that I dated a girl that lived on a road called Leah Way, that he's going to insinuate that it was the same address somehow.
Who lives at 246 Leah Way?
I have no clue.
Okay.
I went to that address after I realized this case existed, and I was told by the manager and owner of the trailer park that the buildings, the trailers that are on it, don't go past 205. So there's no way either one of those two numbers. That's what I was told by the owner.
Okay, well, but that 246 Leah Way address,
I've
was
never
that
heard
your
of it.
address?
No, I've never. I lived in Indiana.
Now, the prosecution brought the numbers 246 up in a different area. Leah Way. That's a different area.
And another thing that I caught is it would be a trailer number, right?
Mm-hmm.
That originally had a 1 after it.
Let me explain the address. Okay, so it was on a street called Morgan Street. It had a specific number. Well, that is an entity of a trailer park. Mm-hmm. We learned that after we found out about the case and started researching everything on the documents. We go there, that's a trailer park. So when you go into that one number on that one street, you're going into literally 205 lots. Okay, and there aren't road names. It is a trailer park, and in that trailer park, you're looking for the number on the trailer, and they're in order on the rows. Well, it ends at 205 was it 204 or 205, something like
It was
that.
somewhere around there.
And then you leave the park. So he said 2461, but then in court today he said 246. Well, what's funny about that is that me and her went there. There ain't no 246 either.
Yeah, no.
What? That almost sounds unbelievable. Because according to their website, they have over 250 lots. Not 200 like you said, Chris. Also, in my first video, I showed where his then girlfriend's address was found on multiple websites, showing she lived at 246 Leah Way in 1998 and 1999. And here's the overhead shot of the entire mobile park home with 246 Leah Way clearly marked. I'm going to switch to a Google Earth view now. What you'll also notice is that you don't just enter Morgan Street and that's the end of the park like Chris said, because there are multiple streets throughout the park, again, unlike Chris claimed. This is the office and main entrance to the park, and this is 246 Leah Way where they live together. Now, for those who are extremely stubborn and refuse to believe that 137 Morgan Street Lot 246 and 246 Leah Way are the same address, I decided to take it one step further. I called Madsden Mobile Park in Radcliffe, Kentucky, pretending that I needed to mail a package to these addresses and asked for clarification on whether they were the same address. You will never believe what happened next.
Thank you for calling Massey Mobile Home and RV Park. This is may I help you?
Yes, good afternoon. I had a quick question for you about one of your lots.
Okay.
I'm trying to mail something. If I were to try to mail something, I've got two separate addresses, but I think it's the same lot. I was just trying to confirm it with you.
Okay, go ahead.
I've received 137 Morgan Street, lot 246, but it's also referred to as 246 Leah Way. Is that the same? That's the same address?
246 is the actual address where the RV is.
Okay.
Now, 137 Morgan Street is our office.
Okay, that I guess that clears up the confusion. So because again, I did receive two addresses: 137 Morgan Street, lot 246, and then 246 Leah Way. But you're saying those are the same places.
Yeah, if it gets delivered to 137 Morgan Street,
Yeah.
it will come to the office.
Gotcha.
We have streets in the mobile home park, so each number is on a different street. Does that make sense?
That it completely makes sense. Thank you so much. You were very helpful.
You're welcome.
All right, bye-bye.
Bye.
It really isn't that confusing whatsoever. Chris just likes to make it confusing to sound believable. And now we know without a shadow of a doubt that this is the location of the citation and that Georgette did live there. Let me show you exactly how I also know Chris lived there with her.
Do you recall being charged with careless driving, suspended operator's license, and no insurance in Meade County, I think in Muldraw, August 13th, 1998?
I can only remember being pulled over in Muldraw around that approximate time.
Okay, I don't know if
Because
it's...
I had a CDL at the time, and I had to do some stuff to make sure it didn't affect my CDL abilities.
Okay. But do you recall this case?
Well, I just answered because I don't recall 20-some years ago.
Okay.
I remember being pulled over in Muldraw.
Sure.
20-some years ago, and I don't remember exactly what it was for.
Okay, all right.
I actually thought it was speeding.
Who lives at 246 Leah Way?
I have no clue.
Okay.
I went to that address after I realized this case existed, and I was told by the manager and owner of the trailer park that the buildings, the trailers that are on it, don't go past 205. So there's no way either one of those two numbers. That's what I was told by the owner.
Okay, well, but that 246 Leah Way address,
I've
was
never
that your
heard of it.
address?
No, I've never. I lived in Indiana.
Do you have any explanation as why there's an insurance card with that address and your name on it?
That is my ex-girlfriend's name right there.
And that's also your name, right?
Well, I didn't have insurance with her. I wasn't married to her.
Okay, but that's your name and that's an address that you say you were never at, correct?
I'm sorry, can I See that again, please? Just because I've never seen this and I wouldn't understand why she would have insurance and have my name on her driver's insurance. That's what it looks like to me, is that she got insurance and put my name on her driver's insurance.
Okay.
And then there is, yes.
You remember her living at that address at some
No, I
point?
do not.
Okay, okay. Do you remember being required to show proof of insurance to the court?
To the court?
As on an order of probation?
Can I see it?
That's it, right
Okay.
there.
No, I do not remember this at all.
And once again, Chris takes the opportunity to blame Georgette like he did in his 1999 assault case, this time for putting his name on her insurance with their address reading 246 Lea Way. But don't worry, he has a much better explanation.
Yeah, the prosecutor just threw some shit in there. He had a copy of an insurance card that was apparently the girl that I dated back then, and it had my name on her insurance card. And I'm thinking, well, shit, dude, if that does anything, it proves that she was using my credit or something, like to maybe make her insurance cheaper. I never approved nobody getting on my insurance.
I would think, wouldn't be so much your credit.
Yes,
they
you're probably
do do a
lowering her
credit check.
insurance rate because I was CDL qualified.
That's right.
I had a cheap insurance
I
compared
was
to
just
most.
thinking you're old.
Listen closely, News Now Axe Body Spray, because I'm going to explain this whole thing to you. To do it thoroughly, we have to travel all the way back in time to 1997. In 1997, Chris was cited with a reckless driving ticket in Hardinsburg, Kentucky, but more importantly, it was the vehicle that he was driving, a 1989 white Ford Mustang. This slide here isn't necessarily relevant, however, he completely ignored this ticket and a failure to appear warrant was issued. This warrant never got resolved and was eventually dismissed after 23 years on the books, which to me shows a pattern of behavior. This next citation is the one the prosecutor was just referring to. As you can see, he was still driving the white Mustang. On August 13, 1998, he received tickets for careless driving, driving on a suspended license, possibly because he skipped out on the last ticket or his points had just racked up. But look at charge number 3, no insurance. The following month, on September 2nd, he pleaded guilty to the careless driving, resulting in a fine, and his operating on a suspended license was amended to a no license in possession, giving him an additional fine of $25. But what about the no insurance? Well, he actually got put on probation as part of his plea deal for these 3 charges, with one of the requirements being that he needed to show proof of insurance before December 2nd, 1998. And that's exactly what he did on October 12th. He and Georgette purchased insurance together on the Mustang, with the address being 246 Lea Way, an address he claims to never have heard of, which happens to also be where Chris was cited for possession and drug paraphernalia. The probation requirement was the reason they put this insurance in both of their names, not Georgette trying to lower her insurance policy like he and Tiffany just tried to claim. No, he had to do this as a requirement.
But that 246 Lea Way address,
I've
was
never
that
heard
your
of it.
address?
No, I've never. I lived in Indiana.
Okay, normally for a story like this, that would be enough. But I saved a monster bombshell regarding this address for last. A couple of months later, after all this happened on December 15th, Chris was pulled over yet again and charged with speeding, no insurance again, which was cleared up quickly because he just didn't have proof of his new policy. But the last charge is the kicker. Failure to notify DOT of address change because he was still driving with an Indiana driver's license, though he told the officer he had lived in Kentucky for 2 months. This last line really cracked me up because 2024 Chris is still using the old "I only lived in Kentucky for 2 months" line, which we know isn't true because he was arrested in April of 1999 for assaulting his girlfriend at their Kentucky home. And this is where it gets really interesting. For that new citation, he originally pleaded not guilty to speeding, but eventually agreed to state traffic school. He had the no insurance dismissed because he showed proof of his new policy that listed an address he's claiming he's never heard of. And charge number 3, the failure to notify DOT of address change, was also dismissed on February 17th because he got a new Kentucky driver's license. Now, the only remaining question I had at this point was, I wonder what address was listed on this new driver's license. Surely it couldn't be for a residence he had no knowledge of, right?
But that 246 Leah Way address, was
never
that
heard
your
of it.
address?
No, I've never. I lived in Indiana.
And here is where we go full circle yet again, because we have to revisit the 1999 assault and DV case I discussed last Friday. When Chris was arrested the second time after violating the DV order on April 21st, he actually had another arraignment on that same day because he failed to complete the state driving school that he agreed to because his license was suspended. And deep down in this case file is where I found it. His freshly minted new Kentucky driver's license number with the address of 246 Leah Way. Whew. And that, folks, is what we call ball game.
Got him! Got him!
What a wild story that is. As we stand today, there has still been no decision on if the judge will revoke his probation. I'm going to go ahead and jump in here to give you some updates. While revisiting this case and looking over this entire file again, I found yet another certified court document that shows he did, in fact, live at the address where the citation took place, yet he claims he's never heard of. In 1999, when he was arrested and spent 42 days in jail for violating a DV order, as part of his pretrial service report, the courts ran his driver history record, which, quite frankly, was a bit of a mess. In that case file, a completely different one from the one I just showed you, I found this. When that history was run, it showed his new Kentucky driver's license yet again, with his residence being listed as an address he claims never existed. This makes the 4th time I've now located this address spanning across multiple case files. 4 certified court documents, 4 different case files, on 4 separate dates with 2 of those bearing his signature. This feels like a good time to revisit this clip.
We go there, that's a trailer park. So when you go into that one number on that one street, you're going into literally 205 lots, okay? And there aren't road names. It is a trailer park. And in that trailer park, you're looking for the number on the trailer, and they're in order on the rows. Well, it ends at 204 or 205, something like that.
It was somewhere around there.
And then you leave the park. So he said 2461, but then in court today he said 246. Well, what's funny about that is that me and her went there. There ain't no 246 either.
And it wasn't just his audience he was saying this to.
But that 246 Leah Way address, was that your address?
No, I've never. I lived in Indiana.
I suppose he just thought no one would bother to look. Why did I decide to look? Well, first off, I found his entire defense rather unique, claiming that those 25-year-old court documents aren't his, that they're all fake, that those signatures, not his, all fake. I found it intriguing, but it didn't take long to realize we weren't going to get any straight answers from him. So I looked, and I'll admit, I can be pretty stubborn at times. Since I made this video back in April, there's still been no resolution. From what I understand, there have been at least 2 continuances, and the next court date isn't scheduled until October 28th. Will we see an outcome? Who the hell knows? This is honestly one of the silliest court cases I've ever come across, and to be frank, he seems to have much bigger problems looming. According to the Kentucky court website, and by his own admission, he's currently facing over 10 charges in Meade County, Kentucky. While I have very few details about this case, I do know, once again, there are allegations of fraudulent documents already. When the time comes, I'll be covering that case just as thoroughly as I did this one, with a full set of court documents, and once again, I'll let the chips fall where they may. Let me leave you with this thought regarding this 25-year-old case. Corruption exists. We see it every day, and I'm certainly not naive to it. Our government is enormous, with the federal government alone managing an annual budget in the trillions. With this much money and power at stake, it's no surprise that some nefarious actors try to exploit it. But this? A 25-year-old case involving allegations of forged signatures, fraudulent documents across multiple jurisdictions, a fake attorney, a non-existing address, and a decades-old fabricated warrant? And all for what? To jail a YouTuber for 30 days? In my opinion, this only serves to muddy the waters for those genuinely committed to exposing government overreach and corruption. All right, everyone, I think we're going to end the video today. I want to thank you all for sticking with me for this long. This is Dummy Kruger, and I'll see you on the next one.